Associates presents the Advisors Forum, the basics of non-judicial settlement agreement, trust termination, and trust decanting. What advisors need to know. The following presentation is for educational purposes only. It is not intended as legal advice or as a substitute for legal advice or legal counseling, and does not create an attorney-client relationship.
Welcome, everybody. Hello, how are you? How are you today? Good. My name is Jeff Stauffer. I'm the Community Relations Director with Elville and Associates. It's a pleasure to be here today. I want to welcome you to our Advisors Forum series. I see a lot of familiar faces and some new ones, and that's always wonderful. At Steve's request, I'm going to keep this brief because he knows how much I like to talk. But a few very brief items. This is very casual, as many of you know, so please get up and get food as you like. We have coffee in the back, and restrooms are up on the second floor directly above us. For CFPs, you may receive one continuing education hour for attending today, and I'll be passing out an attendance form for that. And for CPAs, you may also receive one CE hour for attending as well, so please fill that out as well. Our final Advisors Forum of the year is going to be on Wednesday, December 13th, same time and same place, so mark your calendars for that, and invitations will be forthcoming about a month ahead of time for that. Today's speaker is Mr. Stephen Elville, Principal of Elville and Associates. His work is centered in elder law, estate planning, and special needs planning, with a special emphasis in areas of tax planning and asset protection. I had about 15 more minutes I wanted to say about Steve since he's such a great guy, but he's cut me off. So there is Steve. Okay.
Thank you, Jeff.
Thank you very much.
How's everybody today? Thank you for coming. And it seems like forever since we've done this. Jeff, when was the last one? June?
Yeah.
June. We normally have a forum in September, and we're a little bit behind this year, I guess, just with scheduling. So thank you for coming. Without you, we would not be able to do this. And you're a very distinguished group, I can see from the list of people here today. So thank you both. Thank you all for coming. All right. In the handout, I wanted to point out something that we have a little challenge with our example page. Did not get printed, and it's being brought over right now. So you're going to get an extra page when we finally get to the examples, which is very important. So right at the end of the presentation, you're going to get another page. Also, I've given you a couple of handouts about really the Maryland Code, certain sections of the Maryland Trust Act, and a list of statutes that I honestly got at a recent presentation that I thought would be very useful to you about various modification of irrevocable trust statutes throughout the country. And then you'll see this blue sheet, which I'm honestly saying I stole from Steve Oceans, who is a very well-known asset protection lawyer in Las Vegas. And he makes this freely available to certain members of Wealth Council, so I've just taken the liberty of handing this to you today. And it's a great list of the decanting states and the statutes. So today, as I was telling Thomas and Janelle, this is going to be a little bit of an academic slog for a while. And it feels a little warm in here, so hopefully if it gets too warm, Jeff will turn up the air or we'll let some air in here. But we're going to slog through some things that I think will have some value to you, hopefully residually, eventually, when you run into these kinds of situations. The purpose of this today is to give you something to take away that when you run into these situations as advisors, you're going to say, wow, maybe this trust can be modified or terminated or manipulated in some way that I didn't realize it could be done so easily. Maybe it's not such a big deal. But as we're also going to talk about the modification of trusts and all of these types of things can be very scary, and they require notice, and there's certain regulations, and there's tax consequences perhaps of doing these things. So we don't want to just approach it willy-nilly. But the other thing to really take away from today is that we don't need to necessarily be restricted to just Maryland law. So one of the nice things about the broad scope of the information I'll share with you today is that hopefully you'll take away that there are other jurisdictions available that if we can't accomplish what we need to do in Maryland, perhaps it could be done somewhere else, as strange as that sounds. And a lot of lawyers restrict their practices only to one jurisdiction. But in this competitive environment today, it's not necessarily the right thing to do. And of course, that's up to you. So, or as advisors. So hopefully you can take away something today. If we can get through this academic portion, which really represents most of the presentation, we'll get to the examples, and hopefully you can take away something. So let's just get into the material. And Jeff, because we don't have our clicker, is it page down, Jeff?
Page right.
Page right. Okay. Our clicker is there we go. All right. So what we're going to cover today, we're going to get into the current landscape in estate planning, elder law, and special needs planning, because as you're going to find out today, trust terminations and modifications can be done throughout the spectrum of trusts, regardless of their purpose. Trust modification and reformation, decanting, and termination. We're going to get into the overview of these concepts, why they are important to know about, in my opinion, and what are the positive and negative outcomes for clients. Understanding a little bit about the Maryland Trust Act, which is the basis of trust law in Maryland. Understanding the basics of non-judicial settlement agreements. And I know this is a lot of legal stuff, but I think what I gather from you as advisors is that you really want to know all you can possibly know to help your clients. And I think financial advisors especially are on the leading edge of many of these things today. Understanding the basics of trust decanting. Understanding trust terminations, and of course examples, and so forth. All right, the current landscape. Well, this is no news to you. We're living in a changed landscape. Estate tax is not an issue for 98.9% of people in the country. Many of you are already aware of the proposals by the Republican majority. I'm really surprised about the proposals, for example, to get rid of the estate tax. I'm really surprised at the skepticism of people who are wealthy. I would have thought these are the folks that will be on the bandwagon, but my experience is they're very skeptical about anything really happening. So I don't know what your experience has been, but obviously these things are on the table. Older trusts may no longer be needed, and I put that in quotations. They're certainly not needed for tax purposes in many instances, but do we want to just go ahead and terminate many of these trusts willy-nilly? And I think the answer is no. We want to be very careful if we're thinking about terminating a family or bypass trust just because people think it's not needed anymore for tax purposes. Portability has changed the landscape. We've talked about that before. The need or demand for flexibility. I don't know if you've noticed this, but as the estate tax recedes into the background, at least for right now, a lot of folks are planning for asset protection. I mean, let's face it, estate planners for the last 50 years focused on estate tax planning. And now there's other topics. There are other things to talk about. And asset protection is right up there at the top of the list. It's not the only thing, but longer time horizons for trusts. And do we need flexibility in building those things in? What if a trust needs to be changed down the road? First thing that comes to my mind is a special needs trust. What if the laws change? We had 2 failed attempts to repeal Obamacare and really reset the stage for Medicaid financing in the United States. And that hasn't happened, but what if that had changed the way special needs trusts are handled? Maybe they needed to be redrafted. Do we need flexibility? And of course, competition between the states. As you look at some of those handouts, you'll start to see how the various states view decanting and other extreme measures and how they're trying to reach out to people to bring their assets into their states. Of all these states for asset protection, does anybody have a guess about, if you haven't heard me say this before, which state has the most assets by far? Any guesses? Nevada is a good guess. Delaware is another good guess. Alaska is a very good guess. South Dakota has more than all the other states combined. South Dakota. So Wyoming, for example, a wonderful state for asset protection. My understanding is that Wyoming has an LLC statute that provides charging order protection for only one member of an LLC. Whereas in other states, you have to have 2 members to really have effective charging order protection. And so Wyoming, keep that in mind. They're up and coming, I think. All right. All right, so what are the common reasons to modify an irrevocable trust? Well, we might want to design the share of a beneficiary. We might want to extend the term of a trust. How many of us have dealt with trusts that terminate at a certain point? Okay, they terminate when a child is 25 or 30, right? Or for other reasons we might want to extend. We might want to accelerate a future interest of a beneficiary. We might want to remove an income distribution that's mandatory. The old-fashioned powers of separating or severing trusts, we might want to do that. We might want to change a support trust to a discretionary trust. So this is a huge issue today. Is a spousal trust an available resource for Medicaid purposes? The health, education, maintenance, and support trust that was left for a child, is that an available resource, and does that need to be changed? Well, it can be changed through decanting, and you're going to find that out today. Or add a beneficiary indirectly. So by granting powers of appointment, we can actually add beneficiaries if that's desirable. In elder law, we might modify a trust for Medicaid purposes. We have a situation right now where a very proactive couple, where one of the spouses has an impairment, and you're familiar with these cases, they did a Medicaid income-only trust through a lawyer in Annapolis, and I know this young lawyer, and like all young lawyers, he put everything but the kitchen sink in this trust, and he was doing what he thought was best, but in hindsight, this trust really shouldn't have all of those gadgets in it, because those things are being scrutinized by various states. So we're looking at that trust to modify it by non-judicial settlement agreement, but there are things that need to be done that we're not quite sure we are allowed to do by non-judicial settlement agreement. And what's one of the biggest things we would be worried about if the grantors funded that trust 3 years ago and they're trying to get past this 60-month look-forward period? We would be worried about resetting the 5 years, right, if we modify that trust. So those are the kind of considerations we're worried about there. Tax considerations, we might modify a trust to get a step up in basis. We might modify a bypass trust or terminate that trust. Or we might choose to provide trusts for beneficiaries with their consent, of course. I don't know if all beneficiaries are going to consent to that, but maybe there's a need for asset protection where there wasn't trust protection otherwise. To save state income tax on undistributed income, the non-grantor trusts that are allowed in states like Nevada and Delaware, that we might move assets to those jurisdictions to try to avoid state income tax. Trust administration, changing trustee provisions, adding a trust protector. Lots of trusts should have a trust protector. In Maryland, we call it a trust advisor, and we'll get into that in just a minute. But they don't have one, and that's one of the things that you might do by modifying a trust. Separating trusts, combining trusts, changing the governing law of a trust, or correcting, God forbid, drafting errors or ambiguities. So modifying irrevocable trust, we're going to get into these concepts now. And why would clients be concerned about this, or why should they know about it? Well, they might have more choices. So one of the things I think I'm happy about in trying to reach out to other attorneys in other states to really kind of have a network of people I can go to if we need to use their jurisdictions is that it gives clients more choices. And I think clients like that, especially with regard to LLC planning. So for example, I was at a conference last week and this person from Wyoming was talking about their statutes, and I said, what about LLC conversion? How easy is that? She says it's extremely easy in Wyoming. You can convert a Maryland LLC to a Wyoming LLC with just a simple form. So, it sometimes may not be that simple, but it's pretty simple sometimes to do these conversions and get clients into a better asset-protected situation. More security, more peace of mind. I put question marks by that. This doesn't matter to everybody, but for some people, when they're fully informed about what's available in these jurisdictions, it really does matter to them. More peace of mind. We have lots of clients that when we tell them about what's available in other jurisdictions, which obviously we are not barred in these jurisdictions, but it really broadens the scope of our value, I think, to them. Modification only with the consent of all parties. Well, you may be surprised to find out that in Maryland, a trust can be modified without the consent of all parties, as long as their interests are adequately protected. So in some states, it would be all parties have to consent, in other states not. And of course, we have to be worried about notice even to children or representation of children or unborn children, and we would call that virtual representation. So lots of things have to happen for this to be fair and equitable in situations where we're not using court approval. And some people want to have a change in fiduciary succession. So in that same case I was just talking to you about the Medicaid trust, the son, one of the beneficiaries, was married, still is married, but since the time the trust was formed, he has gotten separated and they're heading toward a divorce. And now they don't want the daughter-in-law in that particular example to be one of the successor trustees. So that's one of the reasons why we might want to modify a trust. And it's important that people know that they can do this, and I think that's what the point is here. All right, so what are the most common approaches? And I know this is pretty dense, heavy stuff, so I appreciate your attention. Well, modification by consent, we talked about that. Let's just cover that real quick, and we're going to get into greater depth. Consent meaning just everybody agrees by mutual consent. Everybody agrees. We might call this, and when I was a younger lawyer, we might call this a common law termination. Everybody agrees, everybody signs a waiver, and everybody's happy. And that's what we used to do. Judicial reformation. This just means the court makes a modification. And that's available in all states. Non-judicial settlement agreements. So this is what we're going to get into today a little bit, where you're allowed to do certain things to a trust if everybody agrees and you're not violating a material purpose of the trust. And it's interesting, material purpose doesn't seem to be defined anywhere. I don't think even the Uniform Trust Code defines the material purpose, but basically it's reasonable, it's not violating the grantor's intent for what they're wanting in the trust. Trust protector amendments. This is kind of like the wild, wild west. In Maryland, we're going to get into the trust advisor, but in Maryland, a trust advisor can basically do anything that the grantor allows them to do. They basically can amend or restate a trust. And of course, decanting. So on a scale of 1 to 100, 100 being the most aggressive and 1 being the least aggressive, I would say decanting is about a 95. It's very aggressive. It's a provision that probably should be in most people's documents, but they need to understand that it's in there, and they need to understand the kind of authority they're providing to literally change an old trust into a new trust. Not just amending a trust or restating a trust, but to completely change it from one trust to another. All right, modification by consent. Allowed in most Uniform Trust Code states. Maryland is not a pure Uniform Trust Code state. It requires the consent of grantor and all beneficiaries. You can terminate the trust or modify the trust. No court approval is required. It's allowed even if it's inconsistent with the material purpose of the trust. So I think from my limited observation that this is still being done in Maryland all over the place. This is what I would call a common law termination of trust. But I think if push came to shove and one of these beneficiaries were to say, or one of the consenting parties were to say, hey, wait a minute, I didn't know what I was doing when I did that and took it to court, I'm not sure it would be allowed because Maryland sets forth the circumstances under which a trust can be terminated and how it can be modified. So I'm not sure that a common law termination or modification without following the Maryland rules would really fly if push came to shove. But the reason it probably flies in many cases is because the consenting parties release one another and go about their business. So I think unless there was a suit over some issue, it would probably fly under the radar screen. Now, getting back to that real quickly, I'm not endorsing that. I'm just saying that I think it's being done out there still. And it probably shouldn't be, because it probably doesn't adequately protect the interests of all parties. All right, judicial reformation. I'm not going to spend a lot of time on this because you came today to find out how to modify trust without going to court. But I think we have to throw that in there. It's allowed in all states. The outcome can be unpredictable. How many of you have gone to court before? Judge likely to be unfamiliar or uncomfortable with trust or trust law. It's best to simplify everything that you might request to make it as simple as possible. But in some jurisdictions, it might be used to add a trust protector. So since Maryland allows what we call a trust advisor, I think going to court, the judge would probably allow the addition of a trust protector. And then with judicial reformation, it might finish the modification of decanting a trust by using the trust protector to restate the trust. So where I'm going here is once a trust protector is appointed, a lot of the things that you might have done if you modified the trust a different way, the trust protector can just do it. So sometimes you can just appoint a trust protector and they can do the things that you wanted done or that the trust needs to have done. I'm going to take just a sip of water. Jeff really cooled it off in here, so if you're cold...
72 to 69.
All right. All right. All right, so the second most common approach is just what we were getting into there, the trust protector restatement or amendment, okay? Now, the trust must contain provisions to allow a trust protector, okay, or allow for the appointment of a trust protector. We'll call it a trust advisor in Maryland. There's no requirement to notify the beneficiary. So see, here are the little nuances. If you have a situation where the client, it's in the best interest of everybody's best interest of your client, some of these techniques require notice and others don't. And that could be a big deal. Trust protector may or may not be a fiduciary. And I would venture that in Maryland, all trust advisors have to be fiduciaries, okay? The trust protector does not. Well, I think that's a mistake right there. So I think what we want to say, the trust protector would restate an original trust or a subtrust. So let's think about this for a minute. There may be occasion that a trust protector would restate a subtrust. A subtrust that is a general needs trust for health, education, maintenance, and support. If I had to do that, I'm not sure I would rely on a trust protector authority. And without getting off the track too much, as you see these trust protector powers we're going to talk about, and Dan and I have talked about this many times, the liability of a trust protector, can you imagine, is enormous. And so, you know, we're going to have to be worried about what we're telling the trust protector they're allowed to do. And I'm not so sure that under those circumstances, amending a subtrust would be something I would use a trust protector for. But I'm just saying there seems to be no limit on what a trust protector could do. Potential powers of a trust protector. And for those of you not familiar with the trust protectors, I know I'm throwing out a lot of stuff to you. A trust protector is a special fiduciary who basically has certain powers that are granted by the grantor. And there are various opinions on this about what their purpose is. My view is that the trust protector's job is to further the grantor's intent. That's my view of it, but there are other views. And so potential powers of a trust protector to amend a trust, change the governing law or situs of a trust. Let's just take that one for example. One might argue that an independent trustee should be the person that does that and not a trust protector. But a trust protector is an arm's length party that the IRS and the world of, let's say, creditor law seems to recognize as having independent authority when granted by a grantor. Terminate a trust, decant the trust. A trust protector in some states can actually decant a trust. Remove or appoint trustees, that's one of the basic functions of a trust protector. Receive or reject a contribution to a trust, add or remove the trust makers as a discretionary beneficiary. So without boring you about decanting, here's a quick story. I had a client, I may have told you this before, I had a client who was in his late 50s and not in good health. And he came to me and said, Steve, I've got a situation where I pumped a ton of money and a huge life insurance policy into a life insurance trust. But I'm estranged from one child. It's kind of sad. But I have 3 kids, and one of them I'm estranged from, and I want to remove her from the trust, but I can't get new insurance, and I can't change the trust. And so, long story short, he was able to move the trust to Nevada, decant the trust into a new trust, and remove the child, sadly. But the good news is that the child could be added back in later by a trust protector if their relationship changes. So these are the things that can be done, basically. And that's a trust protector example. Revoke or modify withdrawal rights, approve or reject accountings. How many of you have worked with special needs children and the family is very concerned about who's going to be watching over this trust in the future? Well, the trustee, obviously, but do we want to build in something where a trust protector has the right to review accountings? And many families like that for special needs trusts. And construe the terms of a trust agreement. Now, under the Maryland Trust Act, and this is a very surface overview, so I just want to let you know that as advisors, I think you should know this about what a trust advisor, not a financial advisor, but what a trust advisor has the power to do in Maryland. So as I was reviewing this, I was struck again by how much power they had. They have the power to direct, consent to, or disapprove investment decisions, distribution decisions, or other decisions of a trustee. The trust advisor must act as a fiduciary. And let's get back to basics real quick. A trust advisor is someone that the trustee can direct. The trust advisor directs. And they are given certain power to direct. And that's what this person is doing. They must act reasonably in the best interest of the beneficiaries. They are liable, so they have a fiduciary duty. They are liable for loss to the trust. The trustee is not liable for following the trust advisor's decisions. So I'm sure they're glad about that. The trustee has no duty to monitor the trust advisor, and the advisor's power over investment decisions is really to direct the trustee regarding purchase, sale, encumbrance of trust property, investment and reinvestment, to vote proxies, select investment advisors and managers, and the advisor has the power to direct modification or termination of the trust. Do they have a lot of power? And as advisors, I would think you would want to know about that this is the kind of power this advisor has. Mary Carol?
Steve, would you say that a trust protector is typically an attorney?
Well, I think what happens most of the time is when clients are faced with this decision, they normally want their attorney to be involved, only because they're sitting there putting all their trust and confidence and time and effort into the documents. But what happens is the attorney probably should not be the trust protector, because there's potential for conflicts of interest there. Sometimes I think it probably would be okay, but the attorney certainly can be someone who can appoint a trust protector if one is needed. So the challenge that I have personally, for example, is many of our special needs clients want me to be the trust protector, and they don't have anybody else. But I think there's a real potential for conflict. Dan?
Are these powers in the Maryland law, and they have a period, or they're only some of the powers that you can grant in the house?
Yeah, these particular slides right here about the trust advisor are actually in Maryland law, and they are in the handouts there in the Maryland. So I didn't print out the entire Maryland Trust Act, but it's just only certain pages. So I just want you to know that would be something as an advisor I would want to know. Yes, Alan?
Can the trustee also be the trust advisor? Sometimes the trustee's powers are so broad they don't come to the same.
They could be, but that would be contrary to the purpose of a trust protector. And the reason for that is you want the trust protector to be this arm's length person. It shouldn't be a family member. And I think in some states the statutes actually say the trust protector's powers are null and void, basically, if it's an interested person. So it should be, doesn't have to be an attorney. CPAs are wonderful trust protectors. Family friends that are professionals or retired professionals. In special needs, for example, anyone who really has intimate knowledge of the family and is really trustworthy and is the kind of person who would pick up the ball and run with it and go to the right attorney, that's the kind of person we want as a trust protector. Janelle.
We see a number of these appointments in the documents that we work with. But certainly with respect to Maryland trusts that predate the Trust Act, you may well find that the scope of power, which is defined in the document, is much less than what you're listing here. And so I think the caveat to everyone is to still read the document that defines and curtails what the trust protector can do, unless it specifically references the statute.
Very good advice. So, Sandy Spring Trust, right here. All right. Thank you. All right. What are most common approaches? Decanting. So, we're going to get into this in more depth. I won't go into it right here, but just know it's one of the most common approaches, or has become a common approach, I should say. All right. Understanding the Maryland Trust Act, I'm not going to drag you through this, but I just thought there are certain provisions I would just bring out to your attention. The definitions, definitely I would want to know about that. Everywhere I go across the country, people talk about the Maryland Trust Act. So it was a big deal. And I think a lot of states were impressed by what Maryland did. Janelle says she's not that impressed. But non-judicial settlement agreement. Were you? Okay. Okay. Non-judicial settlement agreements. We're going to talk about that a little bit more. Representation of beneficiaries and how they need to have adequate representation. The creation, modification of termination of trust in general. Okay. Now, I threw the trust for the care of animals in there only because it doesn't get talked about much, but it's in there, and it's important to a lot of people. It has nothing to do with today, but I just wanted to throw that out there. Trust can be terminated if unlawful, contrary to public policy, or if impossible to achieve. The termination can be instituted via court proceeding. And then 410, 411, and 412 are modification or termination of trust in general. Continue. I thought this was interesting. A trust can be modified by a court for tax purposes. It wasn't achieving the grantor's tax objectives. So I would think if you're out there and you run into something awful, this might be something to use. I don't know if Janelle has any experience with this particular provision, but I thought I was happily reminded by that. Creditors' claims really has nothing to do with today, but I wanted you to see that Maryland Trust Act addresses the claims of creditors, and it's something good for you to know about. That's one of the most important things to people today, now that estate tax is not an issue for many people. I thought this was interesting. A trustee with special skills should use those skills. That's what it says. So it seems to me that the Maryland Trust Act is encouraging people to think in terms of broad flexibility in planning and how you think about trust. And if you need to appoint an independent special trustee, by all means, do it. And the trust advisor, and then we're going to get into the trust protector presentation, or slides. I'm just going to check my time to see how we're doing. We're about halfway through. All right, understanding the basics of non-judicial settlement agreements. Now, remember, this is the ability to change a trust without having to go to court. Okay? All interested persons must consent. And here's the broad thing that's hard to get our minds around. The people who must consent are those who would be required to consent if there was a binding settlement in a court. In other words, you can basically agree to anything that a court would allow. And so how are we supposed to know that? But we try to get our minds around that. It must be valid and not void a material purpose of the trust. And here are the basic matters that the code sets out that can be addressed by non-judicial modification. Interpretation and construction of the trust. The approval of a report or an accounting to a trustee. Direction to the trustee to refrain from performing a certain act or granting the trustee a power that they didn't have. resignation and appointment of a trustee. So that example I was just giving you, we have that daughter-in-law in that example of the divorce. She's the divorcing spouse. This is a way to have her removed as a successor trustee. Transfer the principal place of administration of a trust. Dealing with liability of trustees for the certain actions they take. And then an interested person can determine, a court I should say, could determine whether they were adequately represented. You'll find that in that code. And determine whether the agreement really contains terms and conditions that the court could have approved. So let's say a group of consenting parties gets together and they all agree and everything's great. One of the beneficiaries can petition a court and say, hey, did they really have the authority to do that? But the intent here is to, provide the kind of flexibility that makes administration of trusts easier. All right, now we're getting to decanting. So we've gone through several different ways that trusts can be modified or changed or terminated. It literally pours the original trust into a different trust. And it's basically a power of amendment, okay? So we have an ability to amend a trust. And so the question is, should clients have this in their documents? And I think the first thing to think about is Maryland is not a decanting state. I think in the Estates and Trust newsletter of about 6 or 8 months ago, there was an article among lawyers, there was an article that Maryland should have a decanting statute, and I think in the future it will. So to my knowledge, and you have the list in front of you, but I believe Delaware and Virginia both have decanting statutes, or surrounding states, but we don't. So just know that Maryland does not. So this whole concept involves moving a trust to another jurisdiction for this purpose. It's based on the trustee's power to direct principal. 26 states have decanting statutes, and 7 of those, can you believe this, do not require notice. So this is another consideration. And I'm not saying it's good or bad. I'm just saying these are the things that are out there when I'm talking about states being in competition with one another. Provisions vary widely, and I've just given you a few here. Delaware, Nevada, Alaska, South Dakota, Wyoming. Generally, the trust provisions override the statutes, and if there's no decanting statute, decanting can still be used so long as the trust contains decanting provisions. So our view on this would be, and I probably would say we want the consent of all beneficiaries, certainly, but a decanting could be done with the consent of all beneficiaries. I would say that, in my opinion, if we were going to decant a Maryland trust, we should move it to another jurisdiction and then have it done there. So, but it's theoretically possible to do it in Maryland. It requires an independent trustee. There may or may not be notice requirements. It must not reduce any fixed income, annuity, or unit trust right. It cannot defeat the exercise of the beneficiary withdrawal right. And it must provide for one or more beneficiaries of the original trust. So I think the question here for clients is, how much flexibility do they want? And I'll tell you what scares clients. What scares most clients is this last one. The trust must provide for one or more of the beneficiaries in the current trust. So if it's a typical family that just wants equal distribution among the 3 children, this is very scary. So in some trusts where they want decanting, I will put, if decanting happens, it must provide for the same beneficiaries. So you can't pick and choose who the beneficiaries are going to be. But remember, that's just the typical concern of a parent who wants to be open-minded, they want to have all the flexibility, but they're scared about their child being taken out of the trust at some point. In a perfect world, all parents would allow, all grantors would allow decanting, and they would trust the trust protector and the trustee and the independent trustee to do what they would have done under extreme circumstances. But obviously this is very scary stuff. So broadest flexibility, any beneficiary could be removed, but otherwise I would not have that in the documents.
Did you give the trust protector the power to remove the beneficiary?
Who's asking?
Sorry,
oh, I'm sorry, Thomas. Would I give the trust protector the power to remove a beneficiary? My reading of the Maryland Trust Act is that it would be allowed. I used to be concerned that that was too aggressive, but in rereading it, I think it's allowed. I think if you do that, you have to have a trust protector who really understands the liability that they're getting into. And I think the trust needs to indemnify the trust protector for that liability, which is a concern about draining the trust for other beneficiaries. But I do think that's an extreme measure that may be best left for other jurisdictions. All right, termination with a court order. So I know we're moving around here. If the court finds that modification is not inconsistent with the material purpose of the trust can be terminated with the consent of all beneficiaries. So remember, pure consent just means common law termination. We have no court authority. But when we do have court authority, generally with the consent of all beneficiaries, we should be able to terminate the trust. The existence of a spendthrift provision, which I feel is very important for beneficiaries, will not limit the termination of a trust in Maryland. Termination allowed, of course, we talked about this, even if the consent is not unanimous in Maryland, if the interest of the non-consenting beneficiary is adequately protected. And the court may modify or terminate the administrative or dispositive provisions of the trust if the court finds that there are circumstances not anticipated by the settlor and where modifications will further the purposes of the trust. The intention of the settlor, obviously, is very important. Also allowed to avoid waste or impracticality. Probably something we should be doing more of, and we try to do this, is get our settlors, grantors of trust to really talk about their intentions and to take the time to write a page or two of what their intentions are so that we can document that in a file. Now, termination without a court order. A trust can be terminated if the assets are less than $100,000. So this is pretty common knowledge out there among lawyers since the Maryland Trust Act came out in 2014. Notice is required to all co-trustees and qualified beneficiaries. I don't know why the code says co-trustees, because not all trusts have co-trustees. I think what they mean is successor trustees. Brian?
Yeah, so an irrevocable life insurance trust holding nothing but a life insurance policy has less than $100,000 in cash value. Let's say it's a $5 million policy. The cash value, the surrender value would be noted to be able to terminate that trust? I
think so. Janelle and Thomas, do you disagree with that? I think so. I think that can be terminated. Yeah. I'm not saying there wouldn't be income tax consequences.
And the Trust Act was significant in allowing individual trustees to terminate under this $100,000 rule. Before the Trust Act amendments, it was limited to corporate trustees, which is probably why you didn't see this used for ILITs before now. Very good.
Very good. Good question. All right, so let's see where we are here. I'm ahead of schedule. All right, very good. And we have our example, so hopefully you can read this. All right, so that was something I know was torturous to go through all that, but I think that should give you 4 or 5 major things to think about how trust can or should be flexible, potentially, in how they're dealt with in administration and what clients should be thinking about and as you spot issues. Okay, we have 15 minutes left, so we have plenty of time. All right. In my example, and there's many other examples we could come up with, an irrevocable trust at death leaves an outright distribution to 3 children. Prior to distribution, all beneficiaries agree that a spendthrift irrevocable trust protection is desirable. And you and I both know a lot of beneficiaries are just going to say, give me the money. And they're not going to want this. But there are, groups of siblings who are very thoughtful, or maybe maybe one of the siblings has an issue. I had a client recently who he always made me laugh. He was actually the son of a client. Made me laugh so hard when he would come to the office. And I'm kind of sorry that the representation is over. But his father died and left him money at exactly the time he had started a restaurant in Rockville. And kind of everybody knew the restaurant wasn't going to make it too well. And sure enough, it didn't. And he owes money on a huge lease that he's, on the hook for. And, if Father had left him an outright distribution, there's a potential. Now, thank goodness the Father left him a distribution in a spendthrift trust. But there's a potential for outright distribution. In that example, could have been changed to a sub-trust that was a spendthrift trust. So let's think about how this would be dealt with, even though it's probably not something you're going to see every day in your practice. But I think the trust could be decanted. It could be moved to a decanting jurisdiction. I'd have to analyze it, but I'm not so sure it couldn't be done with a non-judicial modification. But something tells me that, that might be a bit aggressive if we were to do a non-judicial modification of the trust. So what we want is we want something that's really rock solid for this beneficiary. And so I would think that decanting this particular trust to a jurisdiction that expressly allows for this kind of outright distribution to be changed to spendthrift protection trust, I think that would be what we would do there. And in my example that I gave you earlier, the irrevocable lifetime trust that we are dealing with names a daughter-in-law as a successor trustee. The grantor's son is now separated from the daughter-in-law, and the grantors want to remove her as a trustee. So this is where we can simply use non-judicial modification of a trust to achieve what they want. And I think most people would agree that that does not violate a material purpose of the trust. All right, and I apologize for having gotten into some of these examples too soon. The decedent has left a support trust for a beneficiary with an individual with disabilities. And a third-party special needs trust would be appropriate, meaning a trust that is generally for the supplemental needs or discretionary needs of the individual, and we don't want that trust to be an available resource for public benefit purposes. And if this general needs trust, and when I say a support trust, I'm talking about a trust where the beneficiary technically has a demand right for public, in the sense of, in the eyes of public benefits, or the world of public benefits, this beneficiary has a right to support. And so that would potentially be a big problem for someone who had special needs, was on Medicaid, SSI, any kind of means-tested agency-related benefits. So here we can transfer the trust through the appointment of an independent trustee. We can transfer the trust to a jurisdiction where it can be changed to a discretionary trust. So a third-party special needs trust is really a discretionary trust and is not an available resource for public benefit purposes. An irrevocable trust has no trust advisor, meaning they have no trust protector. And it's desirable to have a trust protector. So clearly under the non-judicial modification statute, that could be accomplished with the consent of all beneficiaries. An irrevocable trust needs to be decanted, but it has no decanting provisions. So what would we do? Well, if it were me, I would get on the phone to the major decanting jurisdictions. I would probably start in Nevada and Wyoming, and I would find out what it would take to move that trust through a paper shuffle of appointing an independent trustee whose purpose is to transfer the trust to the new jurisdiction and then have that trust changed to add a decanting provision. Now, whether or not we could add a decanting provision or a trust protector provision, we just talked about that, whether we could add a decanting provision with just a non-judicial modification, I think that would be something we would look at on a case-by-case basis. But that might be deemed to violate a material purpose of the trust. And I think that might be quite aggressive. So that's why I think we can do certain things in Maryland. I think Maryland is a wonderful asset protection state in the sense of there are certain provisions of the Trust Act that allow wonderful asset protection at death and sometimes during life for spouses and other lifetime beneficiaries. But when we go beyond that with some of these aggressive decanting provisions, I would probably move the trust to another state to have this done. Now, one of the questions that comes up a lot, and Janelle may have something to weigh in on here, is whether or not a bypass trust, or what we would in the past call family trust, credit shelter trust, whatever we call it, whether that should be terminated, let's say. This trust is now undesirable. And the surviving spouse's advisor, which I just had a case like this the other day, and she's a wonderful lady with her brother-in-law is her financial advisor, and he's done a decent job for her, and he's telling her, you don't need that bypass trust, just get rid of it. And so any thoughts about this, about would this be desirable to get rid of a bypass trust? This is a trust that, under the old way of doing things, it is a trust that is established for the benefit of the surviving spouse. It's generally for tax planning purposes, which it's no longer needed, in most situations, no longer needed for that, and it provides asset protection for the surviving spouse. Now, with portability, in hindsight, it looks like those trusts were never needed. So why would we keep or get rid of those trusts? Any thoughts? Dan?
Basis step up.
Basis step up, okay. What about asset protection? And right now it doesn't look like this particular person has any worries in life. It doesn't look like there's going to be any estate tax. It doesn't look like there's going to be any issues like this. But what if a new administration comes in and we revert back to $1 million of, I don't think it's going to happen, but what if we revert back to the old system? So I think that, Brian.
I'm sorry, just looking at that 14.5, 414 modification thing you pointed out. With the retroactive, couldn't you just modify it to the point of, what do they call the advisor role, but sort of like a wait and see. Otherwise, have it there, then put that person in place, according to that, says they're doing what's in the best purpose, or best interest of the trust. It gives them that power to do that even retroactively at some future date in case they do change the law.
Wow, that's something I'll have to think about that. Yeah, thank you. Wow, that's good. Email me that, Dan.
I agree with that. Build the flexibility and maintain the trust for the asset protection, but then the flexibility is there to give the surviving spouse the powers in order to be included in her estate if you need to step up at that time or keep it out, depending on where we are in the law.
Very good. Very good. And the other thing I was thinking about is many bypass trusts, of course, can be for the benefit of the spouse and children. And if that bypass trust didn't exist, you're actually hurting potentially the shares of the contingent beneficiaries. So anyway, my point here is that there's a lot to think about there when we are terminating a bypass trust or trying to change it, which of course a decanting statute could. So anyway, those are just 5 or 6 examples. Any other examples that you can think of that you'd like to discuss? I talked about some of these during the presentation, but generally those were the 5 or 6 that I could come up with. Hey, Dan. Yeah.
As I was talking about, these trusts that don't allow capital gains to be part of income, so you can distribute out and do some income tax plan. Which of these methods do you think would be acceptable to change that trust?
Janelle, you had a comment?
I think that the tax code now allows us, to the extent of D&I, to make an election on a trust-by-trust basis, to allocate out capital gain to the extent of D&I. I don't think you can ever get more capital gain than the amount of money that Benny has gotten. In other words, you can't allocate out capital gains if there isn't D&I to carry it out. But I don't think it's a trust provision. I think it's a tax law election.
I gotcha. And I think what Dan might be saying, don't let me put words in your mouth, Dan, is that Matt might say it's got to be a trust provision. Matt, I'm not trying to talk for you or Matt, but I think Matt might say, well, gee, I think that has to be in the trust. But
Well, you have to have some way to get something more than just net income out. You could do it one of two ways. You could either have discretionary distribution of principal, or you could have a TRR election, 4% or something that's carrying out more than ordinary income that could have.
Well,
there's a dispute over
yeah. I think
whether
there's
it allows the trustee to do that without revision of the document. Because under the
like
Uniform Trust Act, capital gain is part of corpus, not part of income. So there's a discretionary to the trustee, but I don't think it's.
So what you're talking about is amending to permit the distribution of principal.
To allocate capital gains to income. So when you distribute income, you're taking some of the D&I out, so the beneficiary pays the tax on some of the capital gains instead of it all being locked up in the trust on the higher rates of the 1041.
And as I think about it, I think maybe all of the techniques we've talked about, almost all of them could probably be used to make that modification. And because one of the things that decanting is really well known for, and trust protectors, is to make changes for tax purposes. And the IRS, even post-mortem, has allowed trust protectors to make changes for tax purposes. So I think pretty much any of them, at least 3 or 4 of them, techniques could be used for that. All right, well, I'm just going to check my time. You guys have been very patient. It's actually 4 minutes early. Thank you for setting through that. I hope that what this does is kind of plan in your minds that there's this underlying bubbling cauldron, I guess, of ideas surrounding how to potentially change trust if flexibility or modification is needed. Maryland allows a certain amount of this. Other states are much more aggressive. Trusts are not trapped here in Maryland necessarily. There are things that can't be done. For example, I just had a case, real quick, where someone had a charitable lead trust and wanted to add a beneficiary. This person had been involved in a very substantial charitable lead trust for a long time and now was newly married and his life has changed and they want to add a beneficiary. And I looked high and low, and you can't add a beneficiary to that kind of trust, even through decanting in any jurisdiction. So there are limits to these things about what can be done. But just know if your client is stuck in a situation or they're concerned, or you look at something and you say, this just doesn't make any sense, or the planning attorneys or trust officers you're working with don't think it makes any sense, there's a possibility things can be changed. Yes, Janelle?
I'm curious about finding the independent trustee who then makes the decision to move to the
Yes. Yes, you can charge $5,000 a day for that. No, I'm just...
I mean, there's a certain amount of CYA, if nothing else, that's got to go into the independent trustee coming up with the backstory as to why to move it to this other jurisdiction.
Okay, I agree with you. I agree with you. So,
where do we find these people? We may need them.
Well, Dan, I know will do it. No, I'm just teasing.
Where's that in the trust reimburses for the liability of the trust?
That is a great question. So a good contemporary trust will be drafted where the trust protector is indemnified to some degree by the assets of the trust. But I do not believe I've seen a trust that indemnifies the acts of an independent special trustee.
Right.
And so a question I would throw back to you, if you have any input on this, is, are you familiar with professional trustee liability insurance? And where would you recommend that clients get that? And many of you might be familiar with it, but recently I ran into a difficulty getting information to a client about that.
We don't face that because we're a trusted party, so we don't have to.
Mm-hmm.
We've got the bank provided insurance. I have to.
Gotcha. So if anybody has any, I'm getting off topic, but if anybody.
Our insurance division actually does sell that. That's not part of our.
Oh, okay.
I don't know. I haven't investigated the policies. I don't know anything about it. I don't sell premiums, but our our savings bank trust does sell, not the trust company, but the insurance division of Sandy Springs sells fiduciary liability protection. So
Okay, that's great.
Policies out there for
Thank you.
independent trustees.
Thank you for telling me that. And so as Janelle has wisely pointed out, just because an attorney or a CPA or someone serves as an independent trustee, and I know many of your clients, the financial advisors in the room, are increasingly looking to you to fill some of these fiduciary roles, and some of you are allowed to do it and some of you aren't, which is another reason why I thought you should know about this today. But as Janelle pointed out, a special independent trustee is usually appointed to do one thing, and that's it. And they do it, and the trust is decanted or whatever, but who knows whether they would be sued for their actions in the future. So that's a good point. Maybe, to Dan's point, the special independent trustee provision should be in a trust, I think, that there's a possibility of appointing one, so it's very clear. But when that person takes on that duty, they should be advised that they could possibly be sued, and that's a good point. All right, it's right at 2 o'clock, so thank you, everyone. I appreciate it, and have a wonderful week. Email Jeff or I if you have any questions, and we appreciate you coming. Thank you.